Planning and navigating your estate can feel overwhelming. How do you guarantee the right people will be able to help you in your old age? In today's podcast, we are going to simplify estate planning with Christina desGroseilliers. Christina is in the estate group division of Carluccio, Leone, Dimon, Doyle, and Sachs LLC, and she is here to give you the understanding you need to start your estate law journey. Please welcome to Talking Retirement, Christina desGroseilliers. Thank you so much.
Thank you for having me. I'm so excited to be here.
Yeah, we're excited to have you as well. So before we dive into all the great questions that we went over, can you tell us a little bit about how you got into law, state law, how you chose to work with the current firm you're in, just a little bit of background about yourself?
Yeah, sure. So I have been in the estate planning world for about 9 years. So I graduated law school about 6 years ago. I am a Delaware native through and through. I grew up there. I went to University of Delaware fighting blue hens, and then I went to Delaware Law School. And while I was in Delaware, I ended up having an internship at a elder law center. And that's how my journey into estate planning really started and what really piqued my interest. Afterwards, I decided to come up to the Jersey Shore. I took a clerkship in Monmouth County, and my life has evolved since then. I made the Jersey Shore my home. And, when I was looking for jobs, it was really important for me to find an area that I was still really interested in. And that really brought me back to estate planning. And Carluccio has been a well-established firm. We've been in Toms River for over 27 years, and I knew that I wanted to be involved in Ocean County and find a firm that was very involved in the community, and Carluccio does have all of those aspects. And when they were looking for someone to join their estate department, I thought this is the perfect role for me. So I applied, and I have been here now for 3 years. I recently just became partner, so I am very thrilled and happy that I am in that position, and I was so grateful that they offered it to me. And so I just really truly love what I do. I love helping people, and estate planning really gave me that I'm able to help people while also maintaining the legal and law side of things, which was really great. It was a great combination of both.
Yeah, it seems like a perfect fit. Jersey
Yeah,
Shore, field you want, law firm you want, it all comes
yeah,
together.
it really did.
Awesome. Well, yeah,
Yeah.
we're also in the business of helping people, especially older adults. And I think it's
hmm
something that people are unaware of the problems you could run into as you get older and you have to plan your estate and you have to figure out who's taking care of you. We
Absolutely.
talked about just how overwhelming estate
hmm
law can feel. So
It's
we
very
want to start
overwhelming.
with some basics
Yeah.
of some of the very basic terminology. Can you explain what
Yes.
a will is to our
Yeah,
listeners?
absolutely. So, a will is a legal document in which you express how you want your property to be distributed at the time of your death and who you want to be in charge of distributing that property. So, within the will, people have probably heard of the term executor or executrix. That is the person who is going to handle your estate once you have passed away. And again, another terminology is, estate. What is your estate? So your estate is all of the property that you own at the time of your death. And it's the property that you own prior to distribution to your beneficiaries. So it can be real property, personal property, anything that you own that's in your name is considered part of your estate. So again, in your last will and testament, you're determining who you want to get your estate, who you want to have, your beach house that you have, who you want to have your primary house that you own, who you want your baseball cards to go to. That's what your will is determining. And the
No.
executor or the executrix is the person to handle that.
Awesome. Well, I hope I get the beach house over the baseball.
Me too. I hope I get the beach house too.
Yeah, so I think it's good that you step in and take these what seem like advanced concepts and just simplify them. And, let's talk about them in plain English. I think one of the
Absolutely.
ones that I didn't know about that you really dove into is a medical directive. Can you shine some light on that as well?
Yeah. So your medical directive, and one of the biggest distinctions I think that people need to understand about the basic estate planning documents is there are two documents that you use while you are still alive, right? So these documents are in play while you are living. So that's your advanced medical directive and your power of attorney. So your advanced medical directive is a legal document in which you state basically certain healthcare decisions that you want someone to make on your behalf in the event you are incapacitated or cannot make those decisions for yourself. So God forbid you were in a car accident, you ended up in a coma. Who is going to make the healthcare decisions for you when you are not able to speak for yourself? So the advanced medical directive is something that is a document that says, hey, this is who I want to make these decisions. And in the event I am in a situation like I'm in a coma or I am brain dead, these are the medical things that I want done. So I want artificial nutrition. I want water. I want to be kept on a ventilator. And so those are the medical decisions that you are making before that scenario happens, so that your person who is in charge of your medical decisions knows the decision that you would want them to make.
Yeah, an incredibly important document, because
Yes.
isn't it as early as 18 you need someone to have that
Yes.
power over you? Like, your parents
Exactly.
no longer automatically have it over you once you turn
Correct.
18.
Yep. And that's, one of the biggest things we say is, when you're looking, if you have children who are 18, going off to college, going to trade school, whatever they're doing over the age of 18, as a parent or a guardian, you no longer have the right to make medical decisions for them or financial decisions for them. So you need to make sure that there are estate planning documents in place so that, God forbid, there was something that happened, someone has the ability to make the decisions for that person. And I think a lot of people don't really think about that.
No, I mean, I didn't think about it until you mentioned
Yeah.
it about 3 weeks ago. So
Yeah.
it's like, what happens in that situation? And we'll get back to terminology in a second. What
Yeah.
happens in the situation you just mentioned where no one has a medical directive over you and you're in a coma? What happens? Does your family fight with the doctor? What exactly goes down?
Yeah. So what ends up happening is, if there's no one to make that decision for you, your family member is then going to have to petition the court with a legal proceeding called a guardianship. Okay, and a guardianship is a very long and lengthy legal proceeding in which you are trying to almost convince the court that you should be the person that should make these decisions. So there has to be 2 independent doctors that come in to evaluate the person who is incapacitated. They then have to go back to the court and provide them with their findings. There's also a attorney who is appointed for the individual who is incapacitated to represent their best interest. And like I said, if more than one person wants to be the guardian, it can just spiral into a long court proceeding, and just for basic decisions that need to be made.
So you can be sitting there in a coma while your parents and your spouse are duking it out in court over
Yes.
who has control, and
Yep.
you're just sitting in the hospital with no one making any decisions. And this could be, I
Exactly.
imagine, weeks or months, correct?
Yep, exactly. And the biggest and I think most famous case and scenario that this happened was the Terry Schiavo case. And if people are not familiar with the Terry Schiavo case, I definitely think that they should just read into it, because it really provides an insight as to what can happen when you have a spouse or a parent and a adult child who think that their decision is the best decision, and then what ends up happening is they are duking it out in court while you are just sitting there waiting for someone to be able to make a decision.
Yeah, I mean, I think that was probably the most public legal case I've seen since the
Yes.
OJ trial. It was incredibly polarizing, and it just shows how, if they had spent an hour with an estate attorney, they could have avoided years of headache. It's
Absolutely.
crazy.
Absolutely. And it really was a shame, because, the purpose of the advanced medical directive is so that you can give kind of a roadmap to your loved ones as to what decisions you would want to be made regarding your health. And the sad part is that we don't know what Terry Schiavo's wishes would have been, right? Because she did not express them. So she had her husband who thought her wishes would be one thing, and then you have her parents who were like, no, her wishes would be something else. And you lose sight of what Terry's wishes actually would be, because you have such an emotional situation that's really driving individuals, decisions. So you lose sight of that, which is the whole purpose of the advanced medical directive, is so that you can say, these are my decisions and this is what I want to be carried out.
Yeah, 100%. Something I didn't realize was even an option until some of our clients mentioned that it was DNRs, do not resuscitate. Don't bring me back. I'm here with my time, and that's it.
Exactly. Yep.
I think something that's similar to a medical directive, and you could correct me if I'm wrong, is a power of attorney. And it's something we see because we have a lot of people who sign documents on other people's behalf. Can you shed light on what a power of attorney is?
Yeah, sure. So the power of attorney is, again, a legal document, but instead of dealing with the healthcare decisions, you're dealing with the financial decisions of someone who cannot make financial decisions for themselves. So, the power of attorney is also such a very important document. In my opinion, the most important estate planning document, because in the event you need someone to make a financial decision for you, calling your bank, writing a check, paying your hospital bill, paying the mortgage on your house if you're incapacitated, they are not able to do that if you are incapacitated. So again, this goes into those two estate planning documents that are needed while you are living. So that's the advanced medical directive and the power of attorney. And a lot of people, get a little bit confused with the power of attorney and get it confused with the will. But I think the most important thing that people need to understand is that the power of attorney is for when you are living but incapacitated. And some people get worried, oh, I don't want to give someone the right to access my financials while I'm still alive. Well, yes, I can understand that, but it would never be used unless you are incapacitated.
Got you. So there is a safeguard in place. So it's not the
Yes.
second you put POA in, someone's just raiding all your bank
Exactly.
account.
Yep.
Gone.
So long as you can continue making financial decisions for yourself, you can continue doing so. It's only in the event that you need it.
That's good to know. We have a lot of clients who, when they're signing up for Medicare policies, they have a spouse, a significant other, someone who's signing on their behalf due to
Yep.
a POA arrangement. So it is very important because let's say your insurance no longer covers what you need covered. You need to switch things, and it's very dangerous to not have that.
Exactly.
I think one of the last terminologies I want to dive into you with is probate. So what
Yes.
exactly is probate? And this is obviously a very New Jersey centric podcast.
Yes.
How does probate court work in New Jersey?
Yeah. Okay. So probate is the legal proceeding in which a court determines that a will is valid. And it's the legal proceeding in which the executor who is named in your will is appointed and given the authority to then handle your wishes. So probate also refers to, in the event you die without a will, the court is then able to appoint someone to be the administrator of your estate. So an executor is someone who's appointed when you have a will. An administrator is someone who's appointed when you die without a will. But probate is the legal proceeding in which that occurs.
Okay.
So New Jersey
people can also contest during a probate too,
correct.
right?
Yes.
Okay.
Yep. So someone has the ability to contest the validity of a will. That's part of the reason. So in New Jersey, you cannot file for probate unless it's 10 days after the decedent's death. So you have to wait at least 10 days before probate can be started. The reason for that is it gives other heirs or next of kin the opportunity to file what's called a caveat. And that is basically a will contest, stating that they do not believe that this will is valid. Once a caveat is filed, probate is put on hold, and typically what we see is then estate litigation will then ensue. So, the whole reason is the 10 days is to give the opportunity for anyone to come forward with a will contest or a will caveat is what we call. But probate, the term, is just the legal proceeding. And I think people get a little scared with the term probate and they think, oh, I don't want any of my assets to go through probate and I don't want probate involved. But it's just the legal proceeding in which someone is appointed or, estate litigation will ensue. But New Jersey is very probate friendly. I will say that. We are a very, very easy state in order for an estate to go through probate. So it's very simple.
Okay, that's good to know because
Yes.
everyone, probate sounds like one of these scary terms where you're like, oh no,
Yes.
it's going to gobble up
Yes.
everything.
But New Jersey, at this point in time, it's very simple. It's very easy.
Okay,
Which is
good to
good.
hear.
Yes.
So we've covered all the basics, your will, your medical directive, your POA, your estate, your probate. These are kind of the core principles and vocabulary.
Yeah.
When should you get started with your estate planning journey? Is there any right time to get started?
So there's no right time, but as an estate planning attorney, I will say the sooner the better. Okay. So it's never too late. So I don't want anyone to think, oh, I'm over the age of 60. I don't have an estate plan. It's too late for me. Absolutely not. You can do it at any time. And one of the, I know like we talked about, sorry, there's a fire truck. I don't know if you could hear it. Okay, good. One of the best things is, if you're over the age of 18, to make sure that you have an advanced medical directive and a power of attorney. Okay, so those two absolutely should be done. But as far as the wills, the power of attorney, the advanced medical directive, it's never too late to do them. So I always say sooner rather than later, so that, in the event there is some sort of emergency, a healthcare crisis, you're not scrambling at the last minute to try and get your wishes on paper and to see an attorney.
Yeah, I think that brings credence to what we talked about earlier, that if you don't take the plan at the beginning, it's going to make things so much worse. So what are some issues you've run into when people don't properly estate plan and it's all retroactive? Like, how much harder does everything become?
Yeah, it becomes extremely difficult, again, because the whole point of the estate plan is to make sure that your wishes are being carried out. And so sometimes when you wait too long, your wishes aren't being carried out. I have a perfect example. I have a client who came to me. He was with his significant other for over 25 years. They were not married. They left everything to one another. Their lives were so embedded, but they were not civil partners. They did not have a civil marriage. It strictly just significant others. She ended up passing away. The will stated that everything would go to each other. But what they didn't realize is that New Jersey imposes an inheritance tax. So there are 3 levels of inheritance tax for there's a Class A beneficiary, there's a Class C beneficiary, and a Class D beneficiary. When you are a Class A beneficiary to an estate, you are a parent, a child, a grandchild, a great-great-grandchild, and there is no inheritance tax due and owing. So if you are one of those individuals, there's no inheritance tax due and owing on the estate that you are receiving an inheritance from. A Class C beneficiary is someone like a brother or a sister. So at that point, you are imposed an 11% inheritance tax. So if your brother passes away and you are receiving his estate, you will be charged, or the estate will be charged, an 11% inheritance tax on the value of the entire estate. When you are a Class D beneficiary, it's anyone else, friend, coworker, niece, nephew, and that is a 15% inheritance tax rate. So my client came to me. He said, my partner, she passed away. She has a house, but I'm just giving it to her son. And I said, well, the problem is that under the eyes of the law, you are considered a Class D beneficiary. There's a 15% inheritance tax that's due and owing to the state of New Jersey. And he was not in a position to pay a 15% inheritance tax. So it became a huge struggle because that was never her intention, right? Her intention was never to impose a tax on her significant other just because she was leaving him everything. So it's extremely important to figure out what your wishes are, what your desires are, and make sure that they are carried out effectively, because if not, there can be severe ramifications, like imposing an inheritance tax that you didn't even realize that you were imposing.
Yeah, I mean, 15% of a house could be tens of thousands of dollars.
Yes.
And at that point, it's like,
Yep.
hey, guys, even though you never got married, just go to the courthouse real quick and
Right.
on paper, because
Yeah.
it's going to save you a ton.
Exactly. So, there's, depending on who you want to leave things to, depending on what their relationship is to you, it's super important to talk to an attorney about it, because there really can be ramifications.
Yeah, no, it's good to hear. And I think something we talk about a lot, we just talked to a financial planner about long-term care planning. We talk to a lot of people in this space. Something about us as humans is we don't do things until we physically see them. So
Yes.
do you find a lot of people take their estate planning more seriously once they deal with a relative, family member who had to go through all this crap?
Yes, exactly. I see a lot of, individuals that come to me who ended up having a parent who did not plan, and then they dealt with, going through probate and things being a little bit more difficult, because when you don't have a will, there are other requirements that need to take place through the court in order for the estate to be distributed. So I have people come to me that said, oh, my mom didn't plan, my dad didn't plan. I don't want to go through that. I don't want my children to go through that. I also have people that come to me that just received a diagnosis, and they're obviously scared and emotional, and they are now, potentially facing death, and they're like, I don't have anything planned and I want to make sure that I get everything in order. So, it's hard at that time because they're dealing with such an emotional, situation with getting this diagnosis, and now they're trying to get paperwork in order. So it really tends to be that people come to me at like the last hour, and I want people to know that your estate plan can be fully changed. I mean, you can make it one day, and a week from now you could call me and say, Christina, I changed my mind, I want to change the whole thing, and we can change it. So it's not something that you make and it's set in stone forever and you can never change it. So it's better to plan earlier, because obviously your life changes. I mean, even people that are younger, right? They get married. It's super important to make sure that then you create an estate plan so that it references your spouse. You have a child. It's important to reference your child and who is going to be the guardian of that child in the event you and your spouse were to pass away. So, it's super important that as your life evolves, you make sure that you're also evolving your estate plan.
No, it's a great point. I think we find that these can be such emotionally charged conversations, even when everything's right. Even
Yeah,
when you're young and healthy and you're just trying to figure out who the guardian is or where the money is going or
right.
something like that. But taking that little bit of extra time now is going to
Yep.
make things so much less emotional later, because it's like been
Absolutely.
outlined.
Absolutely. And it also really assists with the person or the people that you are leaving in charge, because, you know, they are dealing with the emotional aspect. If you pass away, they're trying to go through the feelings of grief, right? That you just passed. So they are going to be questioning every decision that they make, hoping that it's the decision that you would want them to make. And it just also adds another level of just emotion and stress. I mean, I have a client that, her daughter passed away unexpectedly. She was very young, in her 40s. She did not have an estate plan in place. Her mother is in, her 70s, and she's, trying to go through and distribute her property, and she's just questioning every decision that she makes, because she's like, I hope this is the decision that my daughter would have wanted me to make, and she's second guessing herself. And so it causes a lot of stress and angst on the individual that you leave in charge if you don't have things spelled out. So that's a whole other level that really should be, thought about.
100%. I think we all think of this estate stuff as money and wills, and we obviously see very dramatized versions of people fighting
Yes.
over wills and movies, but really there's a huge human component to all this that's missed. It's like your family and friends are going to be incredibly stressed just dealing with your death, but if you're
Yep.
adding, these crazy contested wills on top of it, it's just
Yeah.
going to make everything so much worse.
Yeah, exactly. So it's so important that, and it's a very difficult topic to talk about. And, when people come to me and my clients come to me, I try and make them feel very comfortable and, make it so that it's not such a scary topic to talk about, because it is. You're thinking about when you are not here, or in the event you're incapacitated, or who's going to be taking care of your child. So they are very emotionally charged questions, but after it's done, I hear it every single time. My clients always say, I'm so glad that this is done. It's a weight off my shoulders. It's not something that I have to think about for at least a while, right? So it's hard in the moment, but as soon as you're done, you will feel such a relief that it's done.
No, 100%. I definitely agree with that sentiment. Something we've been
Yeah.
doing, and I've joked about this in the past, is we have a lot of friends who are in their 30s and 40s who are buying houses, getting married, having
Yeah.
kids, and we've been trying to sell them life insurance. And I always tell this one story of one of my best friends of all time. He's been married for years, and I kept saying, life insurance, when are we going to do it? And one day I just put my foot down and I was like, why have we not talked about this yet?
Yes.
And he went, you know what? I don't want to talk about death. Like, okay,
Yeah.
I was like, okay, I get it. At least you told me. Like,
Yeah. Yeah. Like, okay, so that's the reason. But yeah, it's definitely a hard topic. But once you do it, you just feel such relief. You really do.
all right. So when we talk about estate planning, let's
Mhm.
talk about a hypothetical. This is obviously never anything we want to talk about, but one of your loved ones passes away.
Yep.
How does the estate get processed from start to finish here in New
Yeah.
Jersey?
So typically what will happen is, like I had said earlier, you have to wait 10 days in order to probate a will. So if your loved one has a will, they pass away, the most important thing is that you know where the original will is. So you are not able to go down to the courthouse and provide a copy. You have to provide the original. The reason being is that the court wants to know that it's an original will, that the person who made this will did not destroy a will, and just a family member is trying to admit a copy of the will. So it's very important that if you do execute a will, you know where it is, and your loved one who is going to be the executor also knows where the original will is. So you wait the 10 days, you have a death certificate, and you bring the will down to whatever county's surrogate court. So wherever the decedent passed away, let's say passed away in Ocean County, you would go down to the Ocean County surrogate court. You would provide the death certificate and the will, and then you would be appointed. So there'd be some paperwork that you would fill out, and you would be appointed. At that time, okay, you would get what's called letters testamentary, and that is the paperwork that states you are in charge of the estate. That gives you the legal authority to then begin handling the estate. So one of the first things that I tell people to do is to open what's called an estate checking account. The reason an estate checking account is needed is that when there are bank accounts that are in the name of the decedent, they will need to be closed and withdrawn, and those monies would then be made payable to the estate. So there needs to be an estate checking account for those monies to go into. Debts for the estate, whether that's medical bills, any credit card bills, utility bills, etc., would be paid from the estate checking account. So that's one of the first things that I tell people to do is once you get appointed to then set up an estate checking account. It just makes the whole process easier. A lot of times what ends up happening is that if the person lived in Ocean County, we'll just say, and they had a house, it's usually listed for sale. The executor has the authority to list the house, accept a contract, sign a contract. Anything that the decedent would have been able to do when they are alive, the executor has the authority to also do. Everyone always asks, how long does my estate need to stay open? So typically we say that the minimum amount of time is 9 months from the date of death. And the reason being is that any creditor has the right to bring a claim to the estate within 9 months. So if after the 9-month period, there's no more debts, no creditor has come forward, then we say you can make distributions and then close out the estate. So the executor would then figure out who the beneficiaries are of the estate, and that would be listed in the last will and testament. And then based on that, they would distribute the property, and then we file what's called a refunding bond and release with the court. That is paperwork basically confirming that the beneficiary received their inheritance. They sign off on it, and it basically tells the court, hey, the estate is finalized and it's now closed.
Okay, so even the best laid estate with no contest is probably going to take at least 9 to 10 months to
Correct.
process. And
Yes. 9 months is the minimum for any estate.
Okay, and so can you start paying bills and things during that probate period, or do you have to wait till the end of the 9 months? Like, let's say
Nope.
you roll over okay.
Yep. So, sorry, I didn't mean to interrupt you, but yes, you can absolutely start making payments. So if you get a bill that comes in, you can absolutely pay it. So as the executor, you have a fiduciary responsibility to basically make sure all the debts are paid and make sure that they're completely done. So if they come in, you pay them. The only issue with that is if the estate does not have money and we're waiting on maybe a house to sell, or we're waiting on a life insurance policy to come in and that sort of thing, then it can take a little bit for the bills to be paid. But once they come in, you should pay them right away.
Okay, so that's the best case scenario, but I'm sure it's never that clean.
No.
So what
Very rarely.
Yeah. So what happens when people add caveats and contests and all these different things in probate court and all that? Like, how does that change the process?
So there's a couple ways that, someone can bring an action. For simple purposes, we'll just say that someone is questioning the validity of the decedent's will. They're saying that there was undue influence involved, that the decedent really wouldn't have wanted what's in the will, that this person shouldn't be appointed the executor. It can, I would say a minimum amount of timeline is about 1.5 to 2 years. Again, because this is such an emotional thing, right? A lot of times people come to me with the thought, well, this is based on principle. And the problem with that is that the court is in a position of, they're not ruling on principle, they're ruling on the legalities, right? So it can take a year and a half, 2 years, just for potentially someone to administer the estate or to, distribute some property. And that's not what your loved one would have wanted. So when there is an estate litigation matter, it is very draining. It's costly on the individuals and the people that are involved, and it just takes a very, very long time to figure it out. Most of the time, what ends up happening, especially in Ocean County, what I've come to find is that a lot of the judges will then require that any costs that are associated with an estate litigation matter is paid by the estate. So again, if I were to pass away and my estate is worth $500,000, and then my beneficiaries spend $200,000 fighting it out in court, that's paid from the estate. So it's ultimately reducing their inheritance.
So you guys could fight for years, spend hundreds of thousands on lawyers, and
Yes.
at the end of the day, you end up losing a ton of money in the process anyway. So it's like,
Yes.
and I'm sure there are situations where it's worth it, but I'm sure it also just ends up not really being something that's advantageous for anybody.
Right. Especially because, again, in my experience, about 95% of, the cases that I deal with in estate litigation, we end up settling because we end up getting to a point where, people are tired. They don't want to continue this. And they also realize, like, what exactly are we fighting for? What exactly are we trying to prove? Because again, if we go off of, well, this is principle, this is principle, this is principle, that very well may be the case, but we have to look at the legalities of it because the court is not going to rule on principle. So, perfect example, I had a client who ended up purchasing and making a lot of repairs to investment properties that his mother owned. And, he was told by her verbally that when she passed away, that those houses would become his because he did all the work, he purchased them, but they were in her name. When she passed away, that's not what her will said, right? Her will said that everything was to be distributed equally between her children. So, he's upset because he was promised something verbally by his mother, but that's not what the will says. So the court is basically saying, well, you're saying that your mother said this. The other side is saying that your mother never said this. And the only thing that we can go off of is this document, which is the last will and testament, which is valid. So it's difficult because people are trying to prove that something happened, but the decedent isn't here to say whether or not that was true. And if it was true, they absolutely should have planned for that so that her wishes could have been fulfilled. But the document that we have doesn't say that. So, it's been probably a year and a half that we've been going through this, and it's a very, again, long and emotional process, especially on, the beneficiaries.
Yeah, it's got to be incredibly tough just to see the strain people have with these, big conversations, and there's so much emotion and so much money involved.
Yeah.
Do you have any crazy stories or examples you could give? I mean, that's obviously a very relevant one, but
Yeah.
some of these crazy estate contests that you've seen.
Yeah, I mean, I had, it starts off much bigger, right? So when someone comes to me, there's always a bigger picture that is originally presented. And then once we start working through those big picture items, then it ends up getting to the nitty-gritty. And I had one client who, we worked out a lot of the bigger ticket items. We worked out the decedent's residence. We worked out the decedent's, other personal property that was worth a lot of money. But then it came down to a license plate. And we had one beneficiary and my client fighting over who was going to receive this license plate. And, again, it's very emotional. So this license plate meant something to both of them. But from, a third party looking in, I'm saying, why are we fighting over a license plate? This is something that we should be able to work out, whether that's, you guys come up with an agreement where, he gets the license plate for 6 months out of the year and you get the license plate for 6 months out of the year, but so because it's so emotional, people tend to get into the nitty gritty and want certain things that maybe, we shouldn't even be discussing. So that was one that we dealt with, that, we went, to court over a license plate. And that was handled. But
I imagine like you have so much on your desk and these guys walk in.
Then the judge says, and the judge said to both me and, my opposing counsel, counsel, what are we doing here? Why are we here over a license plate? So, then we have to explain to the court, why we are here and why we are, presenting this issue. Another issue that I had, which ended up thankfully being worked out, and this is something that I also stress, and I'm kind of, diverting a little bit, but I stress to people that are divorced, okay? If you are divorced and you have any sort of life insurance policy or retirement account that has a beneficiary designation. So a lot of times, like I said, we see life insurance policies and 401k accounts or retirement accounts that you need to put down a beneficiary. In the event that has your ex-spouse's name on it, just because you have a divorce decree does not mean that your ex-spouse will not get those monies. So beneficiary designation trumps what the last will and testament says. So if you are divorced, make sure, please, that all of your accounts that have a beneficiary listed is not your ex-spouse. That is so important. And you would not believe how many people come to me and end up going home and saying, oh my God, Christina, I checked and it was still my ex-wife. I didn't even realize that I had her down. And, part of the reason, the legality part of it, is that the court determines that if you put a beneficiary on an account, you want that beneficiary to receive those monies. So it doesn't matter what your last will and testament says. If there's a beneficiary listed, that's going to that beneficiary. So it's very, very, very important that people understand that, because I see it all the time. And that's a little crazy scenario that, we always joke about. We're like, there's another one that people just don't realize to change that. And it's something that people should absolutely know.
Yeah, it's interesting because a lot of this stuff doesn't seem right, but it makes sense, at least in a legal sense. It's like there has to be some sort of precedent. It's just people put it off or decide it's not important because they just assume things will go right. And it's like, no, there's actually legitimate reasons for it to play out this way.
Exactly. And, the law is not always fair, but we have the law so that we can handle these situations that we don't know are going to come up. But the bottom line is that the law states that if you are listed on an account, if you are the account holder, the law says, well, if you didn't want them to receive that, it's your money, you would have changed that beneficiary. So it's very important that people look into that, because I can't even tell you how many clients come to me and then say, oh my God, I didn't even realize I've been divorced for 20 years. I didn't know he was still listed on that account. So very important.
Yeah, and I think a lot of this comes down to things people are like, oh, I'll get around to it. Oh, I'll get around to it. But you never really know when you're actually, everything's going to hit the fan. You need to be ready if it's not ready.
Yeah. And also, I can't tell you how many people come to me and they say, well, I thought that since I got divorced that my ex-spouse isn't entitled to anything. And yes, that is the case in your actual estate. Okay. So again, the real property and the personal property that you own at the time of your death, your ex-spouse would not be entitled to that because you are divorced. But when you are dealing with accounts that have beneficiary designations, that is outside of the estate and it does not follow the terms of the will. So it's very important to make sure that, people can differentiate the two, what's part of my estate and what's not part of my estate. And so life insurance policies, annuities, any retirement accounts that have a beneficiary designation are outside of your estate and will go by the beneficiary designation.
Yeah. So to anybody watching, listening, start this ASAP. Don't wait for it.
Yes.
And obviously, this is all amazing information, Christina. We really appreciate you coming on the podcast.
Yes, thank you for having me.
If people want to talk to you, because don't wait.
Yes, don't wait.
Want to talk to you, how can they reach your firm? What kind of services do you guys provide? Would love to know a little bit more about your guys' process as a firm.
Absolutely. So, like I said, Carluccio, Leone, Dimon, Doyle, and Sachs has been around since 1997. So we are a general practice law firm. So we have land use, civil litigation, estate planning, estate administration, criminal. So we handle a variety of cases. If someone wants to get in touch with me, my process is, I have an initial phone consultation or I meet with the person in my office. I always give a free consultation. So it's a free 1 hour consultation with me to make sure that it's a good fit, that people feel comfortable with me, that, I can absolutely help them in what they are looking for. A lot of people also, are concerned that, they're going to call somewhere, they're going to pay hundreds of dollars just for an initial consult, just to be told, oh, I can't help you, or, I'm not the person that you want to see. That's not what we do. So I do provide a 1 hour free consultation. And then once we discuss what your goals and objectives are, then I tell you, based on my advice and recommendation, what I think that you should, get done. Typically the turnaround for an estate plan, I mean, we can do it within a week, we can do it, within a month, depending on how fast or slow you want to go through it. But, sooner rather the better. And so if someone wants to contact me, my firm phone number is, and I can give it right now, is 732-797-1600. And they just ask for me and they'll be put right to my office.
All right, awesome. Yeah, so I will list
Yeah.
that number and also your guys' website
Thank
below to
you.
anybody who wants to reach out to you guys. But Christina, this is amazing information. People have no idea how important it is to plan this
Yeah.
estate. Me and my brother are actually going to be in the process of talking to our parents about all the stuff they've done, just because we have no
Yeah.
idea where everything is and we need to know. So
Yeah.
thank you again for your expertise.
Thank you so
And
much for having me.
yeah, hope to talk to you soon.
Yes, absolutely.